I will now call 125-672 M&I Marshall and Ilsley Bank versus Kevin and Gretchen Higdon versus Equity Bank.
May it please the court, Chris Kuckelman appears for appellants Kevin and Gretchen Higdon. Obviously, the ultimate question to be resolved in this case is how much, if any, of this bank account is properly subject to garnishment. And that ultimate question depends necessarily and totally on the form of ownership of that account immediately before this order of garnishment was issued. And that's why both the district court and the Court of Appeals based their rulings on the form of ownership of the account. And in that respect, the analysis in this case is properly similar to the analysis that this court employed in Walnut Valley State Bank case. The entire focus in the Walnut Valley State Bank case was on the form of ownership of the garnished account. This court didn't even consider procedural garnishment rules. This court didn't even discuss what types of assets are exempt from garnishment under Kansas law. The entire focus in Walnut Valley State Bank was the form of ownership of the bank account in question. And the form of ownership of a bank account is a substantive issue. The rights and duties of parties under a contract are substantive issues. They're not procedural issues. If interpreting a contract and determining the rights and duties of parties under a contract was procedural, we wouldn't need conflict of law rules like lex loci contractus. And in the context of a bank account, interpreting the contract includes determining the form of ownership of the account. And neither the appellee, the district court, nor the Court of Appeals has explained anywhere that I've seen how determining the ownership of this bank account is a procedural issue, other than just kind of conclusory statements.
Let's assume let's assume it is a question of Missouri substantive law, which would make this the form of ownership tenancy by the entirety.
Yes.
Just take me back to property law 101, I guess. Is that functionally the equivalent of joint tenancy?
Well,
I mean, because they both have rights of owner. I mean, are we using just different labels?
almost.
Okay.
So as this court held in Walnut Valley State Bank, that was a joint tenancy bank account. And this court held that to determine how much of that account should be subject to garnishment, we need to delve further into the equitable ownership of that account between the two account holders.
Well, there's a statutory presumption that once you attach a joint account, it severs the joint tenancy,
Right.
creates tenants in common with a presumption of 50% ownership each,
Right.
which can be rebutted.
Right. But to distinguish that tenancy by the entirety, one effect of that ownership form, maybe the distinguishing effect of that ownership form, is that where you have a judgment debtor and a spouse that own some property as tenants by the entirety, and a judgment creditor is seeking to attach that asset that's owned tenants by the entirety, none of it can be attached.
Under the procedural attachment rules, correct?
No, under the substantive law that gives us the effect of a form of ownership known as tenants by the entirety.
Well, I guess that's the question that I have in this case is, it seems to me whether you can attach is a procedural question. The form of ownership does sound substantive to me. But once you've answered, okay, it's tenancy in the entirety or joint tenancy, then we come back to Kansas law to see whether you can attach to that property under the procedural mechanisms of attachment and garnishment.
I would respectfully disagree.
Okay, and
Because,
why is that?
well, if Missouri substantive law applies to
Defining the nature
conclude
of
that
that
this is a,
asset.
yes, a tenancy by the entirety, then one natural effect, one necessary effect of that is all of the characteristics of tenancy by the entirety. And that's a substantive right. It's not a procedural right. A procedural right or rule would be, what's the deadline for responding to an order of garnishment? Or what's the form that, of the order of garnishment that's served on the garnishee? Those kinds of things.
In a tenancy by the entirety, isn't the point substantively that both spouses own the entire thing? So by definition, if you garnish that account, you are also garnishing the non-judgment debtor's ownership interest in the entire account.
That's correct. That's the essence of tenancy by the entirety, because they each own all of the account.
That's the same under joint tenancy too.
It is, except for
Except when you get into attachment law, it
that,
has a different effect.
that's correct.
And I guess the question is, if property is subject to attachment or exempt from attachment, isn't that a procedural question? Or do we just have is that where you disagree?
It is, it
Okay.
is. So I think it's respectfully, I wouldn't call that a tenancy by the entirety account to be exempt from attachment. The exemptions are those that are set forth in our statutes, like Social Security benefits, life insurance, policy benefits, public assistance, individual retirement accounts, those kind of things are exempt. Those cannot be attached, period. And
For comp.
right,
You know,
but I distinguish, respectfully, I distinguish a substantive rule of law that says tenancy by the entirety assets cannot be attached where the judgment is only against one of the tenants.
and in Missouri, is that part of the attachment code or is that part of the property code?
Well, I don't think it's.
Not that I'm not suggesting that you would make any conclusion from that. I'm just out of curiosity where those are housed.
Well, the statute that provides the presumption of tenancy by the entirety in Missouri, it's certainly not in the garnishment statutes. I think it's in the property statutes. And I think that the effect of tenancy by the entirety is case law. I don't think there's a statute. If I remember correctly, I don't think there's a statute that provides for that.
Okay, that's Missouri common law.
Yes, I
Okay.
think it is.
There is a statute that says it's presumed to be tenant by the
Yes.
entirety.
Yes, but the effect of tenancy by the entirety, I don't think is statutory. That effect of not being able to be attached where only one of the tenants is a judgment debtor. Yeah. But the presumption of tenancy by the entirety is definitely statutory.
Well, in a joint tenancy, if a husband and wife owns property in joint tenancy, the presumption is that each owns half, correct?
Yes, and that's by virtue of the holding in Walnut Valley State Bank.
And then that presumption
Upon
can be
attachment,
rebutted.
I'm sorry, upon attachment? I didn't, is that what you're asking?
No, I
Just wanna make
kind of
sure.
had a second part if I could ask him, but
Sorry about
the
that.
presumption can be rebutted such that there's a finding that one or the other owns a different percentage than half. So one can own all of it, but then if that happens, the other one owns none of it. correct?
That's correct.
But in a tenancy by the entirety, by definition, they both own all of it, and that cannot be separated, correct?
That's correct. And I would contend that is by virtue of Missouri's substantive case law. The,
And if there's following up on those questions, and I'm sorry, I didn't mean to interrupt her, that line of questioning. And so when it passes then, when one of the owners passes, the entirety goes to the surviving, spouse.
yes,
Is that correct?
yes,
It's simply non-divisible then, under Missouri law.
non-divisible, yes, yes, yes. So obviously in Kansas, we've had this long history of a conflict of law rule. I may mispronounce this, lex loci contractus. And as this court is well aware, the law of the state where the contract is made governs the interpretation of the contract. In this case, the contract in question is that account agreement that was signed by my clients and the bank when the account was opened. And that there's no doubt that account was made in Missouri. So under our well-established rule of lex loci contractus, Missouri substantive law would be applied to interpret that contract, that account agreement. And that would include the form of ownership of the account. Court of Appeals refused to apply lex loci contractus by saying that the appellee didn't have contractual privity with respect to that account agreement. In my supplemental brief, I cited a handful of cases where contractual privity was lacking among some of the litigants. But despite that, lex loci contractus was applied to interpret a contract. And one of those cases that I cited was Moses v. Halstead. And that case applied Kansas conflict of law rules to, in a garnishment case, to interpret a contract, even where some of the parties lacked contractual privity. So I don't think the lack of the appellee's privity with respect to the account agreement is any impediment to the application of lex loci contractus. Looks like I'm out of time.
Thank you.
It pleases the court, Ashlyn Lewis on behalf of the appellee M&I Bank. I'm here actually on I think a appellate lawyer's dream case, which is that there are no factual disputes here, purely a question of law. And here's what everybody in this case agrees to. Mr. Higdon agreed to a consent judgment that was entered against him in Missouri. M&I Bank, which was the judgment creditor, registered that judgment in Kansas, at which point it became a Kansas judgment, enforceable as such, subject to execution under Kansas procedures. Then the Kansas court issued a garnishment to Equity Bank pursuant to Kansas law that was served personally on a branch of Equity Bank in Kansas. Equity Bank, in fact, complied with that garnishment order, withheld the funds in that joint account owned by Mr. Higdon and his wife. And the parties also agreed that if the joint account is subject to garnishment, then half of those funds in the account were owned by Mr. Higdon. So the only question here is whether the court, before this court, is whether the joint bank account is subject to garnishment in Kansas. This is a Kansas judgment. It's being enforced by a Kansas court and it's executing on property located in Kansas. Kansas law applies.
Isn't the problem though that the property that was executed upon might not belong to Kevin Higdon?
Well, I think the issue you're referring to, Justice Steele, is that tenancy by the entirety is a legal fiction that says the property is owned by the marital entity as opposed to each individual in the marriage. But
Well, if I'm Gretchen Higdon, I mean, this might be presumptuous of me to say this, but I might be sitting there saying, wait a second, you took my money.
well,
I didn't know that. Dad.
we took his money. I mean,
Well,
that's
but that's the whole point.
That is the
How
whole
do you
point.
know whose money it is? I'm distilling it down into my own simplistic
your own
language.
simplistic. I understand. I mean, my response to that would be that tenancy by the entirety is not, we're not actually arguing about whether Mr. Higdon has an interest, right? He has an interest. This is not like this is property that belongs to somebody else. He has an interest in it. And in fact, the US Supreme Court, and granted, this is under a supremacy clause issue, but says we don't care about tenancy by the entirety in states. We can attach federal tax liens to property that's held by the entirety because in fact, it is an individual interest that this person owns in this account, even if the state says, well, we're pretending under this legal fiction that it's owned by the entirety. So
But we're not the Supreme Court, and so we don't have a supremacy clause. In fact, we have to respect the laws of other states. And in Missouri, and as a person, do you practice in Missouri?
I do.
Right. So in Missouri, you know, that this is for creditors, this has been a thorn in their side for decades and decades and decades, this tenancy by the entirety, because under a tenant by the entirety, which a statute says it's presumed, even if it says joint tenancy, as it does, on the signed sheet, it doesn't matter. It doesn't presume to be joint tenancy with right of survivorship. It's a tenancy by the entireties, which is presumed to be that it's jointly owned and it's all together in one and can't be separated and therefore is not subject to creditors at all, period. Okay, so I think the issue here is, and just focusing on the legal, is how are we framing the question? How are we framing the question presented? Is the question presented as, is this a garnishment issue? Is this a garnishment issue? And the Court of Appeals framed it as a garnishment action, whether the funds are subject to or exempted from garnishment. The Higdons frame it as who owns the funds. All right. So I think it's about who owns the funds.
So
Would you agree?
respectfully, no, Judge. Your Honor, the difference is that the reason we care that it's owned as tenancy by the entirety is because we care whether they can be garnished or not. That is the issue in this case. The only reason that we're even looking at the form of ownership of this bank account is because we want to know, can it be garnished in Kansas?
Would you
By
agree that
Kansas court?
garnishment is procedure?
Yes.
Okay. And the procedure, it's procedural. Garnishment is a procedural mechanism to attach funds. And before you can decide whether you can attach the funds, isn't the first question, who owns the funds? That's the first question we have to ask, right? Don't we?
The first question, I mean, I agree that there is a question of who owns the funds.
Right. So
But
when you
the
say
answer
who owns
is-
the funds, if that's our first question, then the issue becomes, well, whose law should we use to determine who owns the funds, right?
And Mr. Higdon owns the funds. It doesn't matter if
No.
it's.
Okay, so when we get to who owns the funds in it, and we have to say, well, that's going to depend on whether we apply Missouri law or Kansas law. So then we go to choice of law. And then you're kind of stuck with, unless you convince us otherwise, we've used the first restatement. Although I think even if we use the second restatement, it would still come to the same conclusion. But under the first restatement, we decide who owns the funds based on where the contract was made. And where was the contract made? It was made in Missouri.
Under the first restatement, we decide who owns the funds based on where the contract was made. If the issue before the court was the interpretation of the contract, which it's not, it's whether the funds can be garnished. And that's a procedural issue.
Why don't we have to answer who owns the funds before we get to the garnishment procedure? You can't garnish funds if you don't know who owns them.
We're in Kansas, applying a Kansas judgment against property located in Kansas. Kansas does not recognize
Okay,
tenancy by the
So
entire.
that's a fine argument, but the reality is that the Higdons live in Missouri. This bank isn't, the only reason you're able to do this is because the bank that they opened it, somebody took it over and there's a branch in Kansas. So to say, oh, well, the property's located, you know what? The property's located in Missouri too. That's where they're banking. They're banking in Missouri. They're not banking at this branch that you're trying to garnish, right?
And I agree that if we were in Missouri with a Missouri court and a Missouri garnishment, this would probably be exempt from garnishment. But the difference is that we're not in Missouri, we're in Kansas applying a Kansas judgment
Why would it be different?
because Kansas does not recognize tenancy by the entirety as a form of ownership.
Do you have an argument as to your client's right to garnish Gretchen's funds?
I'm not sure I understand the question. So there was a agreement in the district court that if this were subject to garnishment, the presumption of equal ownership applied. And so they've only garnished, or there's only been half of the funds.
If
paid
that was a
over.
tenancy in
Well, and
common
I
or joint tenancy, but not tenancy by the entireties. It's indivisible.
go ahead and answer.
I guess
Or-
I'm not, the question, could
Okay,
you?
go ahead. Sorry.
I understand a legal fiction that they both own all of it. I own if under tenancy of the entirety. So then that means that it's all owned by Kevin and it's all owned by Gretchen if we find its tenancy by the entirety. So your argument is that can be divisible. You're going after Kevin. Gretchen, of course, is going to say, well, it's all mine too. Do you have an argument that you could go after Gretchen's property or not? Is that just completely?
We're not
Funds.
contending that we can garnish Gretchen's half of the property. I think there's a little bit of a false distinction between tenancy by the entirety and joint tenancy, in that one is never divisible and the other can sometimes be. I mean, joint tenancy, also, you presume that both parties or all of the parties also own all of the funds. The difference is that when an attachment occurs, that's what severs the joint tenancy.
Well, actually, my question was a little different.
Okay.
My question wasn't whether you can get to Gretchen's half of the property, but whether you have an argument that you can get to Gretchen's interest in the property.
I guess I'm not appreciating the distinction you're trying to do, and I apologize for that. We're only garnishing Kevin's interest in the property. The question is, when that attachment occurs, severs whatever joint tenancy they may have had and allows the bank to get at Kevin's half of funds.
And so essentially, as I understand your argument, is the first question isn't necessarily who owns the funds, it's how do we characterize the account in terms of a property interest. Under Missouri law, that's in the entirety, tenants in the entirety, which it seems to me that's the same thing as joint tenancy, except for husband and wife, right, specifically. And so even if we characterize that property under Missouri law, if we were garnishing in Kansas, then that is a attachable asset. A property held in the entirety or in joint tenancy is attachable. And the way that Kansas handles that is to split it in half, or at least that's the presumption. But then Gretchen or Kevin can put on evidence that their interest actually exceeds 50% or is less than 50%. And that all gets flushed out where in the garnishment proceedings.
Yes, and I believe in this case, there was actually a stipulation that neither party would be able to rebut the presumption, so there wasn't evidence of it in this case. But yes, that would be part of the garnishment proceeding. But you're exactly right that my argument is that the question we're asking is not who owns the funds, right? Kevin's got an interest in the funds. There's no doubt about that. The question is this joint bank account subject to garnishment? We only would even care about the form of ownership because we're trying to garnish the funds. And that's a procedural question to which Kansas law applies.
And can you address your opposing counsel's argument, I think, was that that's not, in fact, that is a substantive question of law, at least for Missouri, where we have this sort of incidental policy that you don't get to attach or devise property held in the entirety. And that
Yes.
makes it a substantive question. Maybe I'm not doing justice to his argument, but.
I address this in the brief, which is that the line between substance and procedure is not some bright line rule that we can, instantly decide, hey, that's substantive, hey, that's procedural. It depends on the context, why we're deciding whether it's substantive or procedural. Here, the context is we're deciding it because we want to know if we can garnish this bank account. And
Oh,
that is,
Let me ask a couple questions along those lines, which is, yes, even calling things substantive and procedural, when you get close to the line, can become very blurry, and those could even be described as legal fictions. So let's look to the rationale behind these divisions. And why is it that when we look at the underlying facts, the rationale counsels strongly in favor of applying Missouri law? Because what we have is essentially, Justice Standridge gestured a little bit towards this, a garnishment proceeding that happens almost as a fluke or a loophole, whatever word you want to use, because this branch was opened. Okay, now let's go over to Kansas and file the judgment, because we're really getting around an impediment that exists in Missouri law. And why shouldn't the policy of states giving full faith and credit to one another's laws require us to respect Missouri's law and not permit this kind of end run?
well, I would say that for one thing, there's no evidence that there was an end run in this case. So that's a assumption being made.
Well, isn't it woven into the very fabric of the case? And I'm not saying that, don't
Right.
hear me say bad faith in that. It's
Right,
like good law.
I understand.
Let's just say it's good lawyering. I'm just really trying to get at the underlying policy, because choice of law is a policy question at root.
The policy question that I think that this court should be focusing on is when Kansas courts are enforcing a Kansas judgment against property that is, for all intents and purposes, located in Kansas, because it can be accessed in Kansas by Mr. Higdon. Even if it could be accessed somewhere else, it's Kansas property. So this is a Kansas judgment, a Kansas court, Kansas property. The policy is to apply Kansas law.
Well, you
But-
have a legitimate debt or that Kevin entered into with your bank. He owes you that. And you're trying to collect that. So why should we care whether in Missouri, Gretchen owns everything that's in their bank account, and in Kansas, they don't recognize tenancies of the entirety. And in Kansas, we presume it's joint tenancy. Why should we care about that then?
I'm hoping this is not a trick question, but we shouldn't care that Missouri categorizes it as tenancy by the entirety because in Kansas, it is garnishable. It is a garnishable joint bank account.
So if in Missouri, it is owned by Laura, all of it, or Gretchen, all owned by Gretchen, then the minute it crosses the state line, or in it, we have a lawsuit in Kansas because you've registered this debt, it magically becomes only half Gretchen's and half Kevin's.
I would not say it magically becomes because Kansas does recognize joint tenancy, which is again, it's all owned by both parties, right? The only difference between tenancy by the entirety and joint tenancy is that aside from the marriage aspect, whether it can be severed or not. I mean, that's the only difference. So
And the difference in terms of garnishment between these two states is one state allows you to garnish that and one does not. But if our rule of resolving conflicts of law were based on the state with the greatest contact and interest in the outcome, would you agree that that's Missouri, given all the underlying facts? I'm not suggesting that's the rule for choice of law, but if it were.
So I would, yes, that's the rule under the second restatement. I don't think it's
Right.
the rule under the first restatement. But I would push back a little bit on the idea that Missouri is the one with the greatest interest in this. This is, again, a Kansas judgment being forced against property in Kansas. I don't see why Kansas's interests are so much lower than Missouri's that it would be, horrendous to apply Kansas law in this instance.
The property both places. You have a bank in Kansas, but that's a branch of your Missouri bank. So the one entity, one bank. So where is the money? Is it both places, one place?
It's both places. It is wherever, I think, it's pretty clear that the law of attachment applies wherever the property can be attached. So if this was a wage garnishment issue, it was a company operating in both Kansas and Missouri, say it was a Missouri employee worked in Missouri, but, for whatever reason, the judgment garnishment was issued in Kansas. Well, his intangible wages can be attached in Kansas, just like they could be attached in Missouri. Now, Missouri has a exemption that says if you're head of household, your wages can't be garnished more than 10%. Kansas does not have that exemption. But in that wage garnishment instance, if the garnishment issued in Kansas, he wouldn't be entitled to that exemption in Missouri, even though if the garnishment had issued in Missouri, he would have been entitled to it there.
And so with regional banking, creditor just has to find the state with a branch that has the most favorable law to the creditor to be able to grab money in account of a regional.
They're entitled to garnish wherever the property is located. I think what you're suggesting is that we have to look to some other jurisdictional nexus to garnishment besides where the property is located, and that's not the law, never has been. It's where the property is.
You're just saying the property is all over.
Property is
Regional
wherever
bank
it can be accessed.
Or a national
Yes.
bank, this property is everywhere.
Yes.
When you mentioned that about the wage garnishment, do you have a case that says that?
Do I have a case that is in my brief?
I don't want you to, oh, well, I guess you were at Z1.
I apologize. I don't have one off the top of my head.
Okay,
But it is a Missouri statute, head of household exemption.
no, I
10%.
know that, but I'm just saying that in the conflict of laws, is there a case on conflict of laws that specifically says that, if the UMB is over there and over here, and I live in Missouri and I deposit my check in Missouri, and then you can garnish it in Kansas and not be subject to the 10%.
So I don't know of a case off the top of my head that specifically deals with the head of household exemption. I would refer to, it's a Missouri case that I cited in the supplemental brief where they discuss the fact that Missouri, it was the opposite. So it was a Kansas judgment that had gotten registered in,
Right, but that case kind of goes against you, doesn't it?
no, I don't think it does at all. I think it says that wherever the wages can be attached
Oh, your
is
wage, okay.
proper, proper place to garnish them. And whether that's in Kansas or Missouri, whether the person works in Kansas or Missouri, if that's where the
Go
wages.
to
can
what
be-
substantive law applies? What law applies on, for not exemptions, but, you know, like a 10%, you know, I mean, what we're getting at here is, you know, this whole respect for, you know, another state's laws.
So you indicated back at the top of the argument that obviously this is not this US Supreme Court, we don't have a supremacy clause issue. What we do have is a federal system that says every state is entitled to enforce its own laws that to the people and events in its borders. What we have here is a Kansas judgment, Kansas property. It's an event, people within the Kansas borders. That's the constitutional reason that Kansas is entitled and should be applying Kansas law in this situation.
I just wondered whether you had a case that didn't just talk about that you can go ahead and do what you're doing, you know, because you did what you did in this case, just whether or not you would be subject to different, you know, when there's no context at all with Kansas, the only context is that you have regional banking, whether you could use, whether you wouldn't, you know, you wouldn't be subject to that 10%.
I don't have a case specifically on the 10%.
Thank you.
Other questions?
Your Honors, the question here, which the Court of Appeals properly framed, is whether a joint bank account can be garnished. That's a procedural rule to which Kansas law applies. The Higdon's joint bank account located in Kansas could be garnished by an order of a Kansas court executing on a Kansas judgment. So we respectfully ask that you affirm the decision of the Court of Appeals in the district court in this matter. Thank you.
It please the court. This discussion about exemptions for wage garnishment is a red herring. We're not talking about exemptions from garnishment. We're not talking about the types of assets that are exempt from garnishment. We're talking about what the form of ownership was of this account that was garnished. That's what we're talking about.
Don't we have to ask whether it's attachable or not?
We do, but in asking that question, Walnut Valley State Bank, the district court in this case, the Court of Appeals in this case, focused on the ownership of the account. And the only way that I know of to determine the ownership of this account is to look at that account agreement and interpret it under our long-standing rules of how we interpret contracts. And the appellee's lack of contractual privity has there's no impediment at all. And you indicated earlier about respect or deference that we owe to our sister states. One of you did, I'm sorry, I can't remember. And I'd like to direct the court's attention to the Farmers Exchange Bank case. It's been extensively briefed. The district court relied on the Farmers Exchange Bank case. That was a Missouri garnishment of a promissory note. And it was a choice of law, a conflict of law issue for that Missouri appellate court. And in deference to Kansas law, the Missouri Court of Appeals determined that Kansas substantive law determined the ownership of that promissory note, not Missouri law. And as a result, it was subject to garnishment because it was held to be in joint tenancy, not tenancy by the entirety. So that was a situation where Missouri gave due deference to Kansas substantive law. As
Tenants in common, I believe, right?
maybe it was tenancy in common. I apologize. Yeah,
Right.
same effect, I think.
But that seems, I'm just guessing, I guess I get hung up on the distinction. So like, okay, under Missouri law, it's effectively a joint tenancy arrangement. That's what tenancy in the entirety is.
Yes.
Okay, we've deferred to there. And then there's a second question is, can we attach that? And that's where it gets really hard to know this substantive procedural distinction. It gets really hard to flush through.
Respectfully, not in my mind.
Yeah.
Because if we conclude that this account was owned by my clients as tenants by the entirety, a natural effect of that is this quality of them both owning the whole and it not being attachable by a judgment creditor of one of them. And if we just disregard that, if we just nominally say, well, yeah, the account's owned by them as tenants by the entirety, but we're just going to ignore that. We're going to give that no effect. We're going to treat it as a joint tenancy account. We haven't given due deference to Missouri substantive law. And the Court of Appeals in this case distinguished Farmers Exchange Bank by saying, well, Missouri has adopted the second restatement of conflict of laws, and Kansas has adopted the first restatement for conflict of laws. But if you look at and I cited this in the petition for review, the first restatement, conflict of laws, says, just like the second a restatement, that the account in this case, a movable asset, the ownership of a movable asset owned by spouses, their ownership is determined by their residency when they acquire that movable asset. So whether you apply lex loci contractus or the first restatement of conflict of laws, which both this court has applied decades after decades after decades, Missouri's substantive law applies. Thank you.
And thank you to both counsel for your arguments in this case. The court will take this matter under advisement.